there are some key takeaways that I'd like you to have. First is your ethical rules require you to be aware of and understand social media and its impact on a client case. And I know we've talked a lot about litigation today, but if you're in-house counsel or you serve as general counsel to a particular company, social media has become so regulated, especially with publicly traded companies, that there are implications through government agencies on how social media can be used or not used, but also through the NLRB saying that you can't restrict employees' right to speech. So there is a minefield of issues out there that our clients need to be aware of, and it's our job as counsel, litigation or otherwise, to properly advise our clients. And, oh, geez, I don't understand social media isn't an excuse, and state bars have consistently upheld that. Second is, when you're being retained in a litigation matter, counsel your clients on how to preserve their posts and their use of social media moving forward, right? And you need to filter that through our ethical rules as lawyers against guarding against spoliation. So obviously, what exists on the day you've been retained needs to stay in existence. Now, some states have said, how does it need to stay in existence? Does it need to stay on the platform, or can they delete it as long as they preserve another platform? That's going to be a question you need to answer in your particular practice, but you need to advise one way or the other that a client must preserve everything that exists on their profiles. Because what you don't want is, you don't want to not only be facing an ethical investigation by your bar, you don't want a spoliation instruction against your client. Number three, many ways to obtain social media, including your traditional discovery request to a more sophisticated API. That's going to be a litigation decision that you're going to make based upon the needs of your particular case. So that will be a conversation that you'll have with your client in terms of where are we at, where are we going, and what do we actually need to get there. Social media should be offered at trial just as any other forms of writing. Don't let the fact that it's a social media post get you off your game or intimidate you. Treat it as any other writing and frame it in that context to your judge, because they're going to more likely understand that, especially if when they were practicing, it was really before this dawn of social media or high use of social media. And lastly, social media data and information is likely going to be admissible at trial. You need to have your client prepare for that. So when you have that initial conversation, not only preserve it, but assume it's coming in. So go through your client's social media profile with them separately, have your staff do it. Go ahead and identify potentially problematic posts, likes, check-ins, whatever it is, and have those conversations with your client about how that's going to be addressed during litigation. Because no matter what the objection is, privacy, hearsay, lack of foundation, you're likely going to be able to get around that. But you, as the lawyer on the other end of that, need to know how to properly object. If someone's requested somebody's patient profile from the beginning of attorney to now, that's likely going to be subject to a valid objection as overly broad in scope. So when you're requesting things, make sure they're limited and tailored. Again, keep that standard of, if this is traditional writing, what would you be entitled to? Keep your requests very narrow in that regard, and more likely than not, they're going to come in.